I have attended the Derbyshire county season every autumn for 11 years, and I have found it, in the main, a reliable source of minor irritation and very good pheasant. The irritation is predictable. The same families, the same introductions, the same careful assessment of whose daughter has improved since last year and whose prospects have dimmed. I am the Duke of Harwick, which means that every mother in 3 counties has, at some point, trained her best hope in my direction and waited to see what I would do. What I have done for 11 years is nothing. I am not cruel about it. I am simply not interested, and I have found over time that a sufficiency of disinterest, consistently maintained, is its own kind of mercy. The good pheasant comes from the east coverts. This has nothing to do with the rest of this account, but it is true, and I want to record it. The autumn I am describing was my 12th county season, and I had entered it with the expectation that it would resemble the previous 11 in all the ways that mattered. I was wrong about this, and I want to say at the outset that being wrong has never, in my experience, felt quite so thoroughly worthwhile. Her name was Miss Wren Halby. She was 28 years old, the youngest daughter of the Reverend Clement Halby of the parish of Ashfield-under-Moor, and she arrived at Harwick Hall in the 2nd week of October in the company of the Ashford family, who were neighbors of hers, and had brought her as a companion for their eldest daughter, Miss Clara Ashford, who was 19 and very pretty and understood to be the season's primary prospect. I was told none of this. I assembled it afterward from various sources, in the manner of a man reconstructing an event he was present for but not paying sufficient attention to at the time. What I noticed, the evening of the first dinner, was a woman at the far end of the table who was not performing. This sounds like a small thing. It is not a small thing. 11 years of county seasons had made me acutely sensitive to the specific quality of a room in which everyone is performing eligibility, performing wit, performing ease, performing interest in my opinion of the pheasant, and the specific, unusual quality of a person who is simply there. She was simply there. She ate her soup. She listened to the conversation around her with the attention of someone who finds most things interesting and most claims worth examining. She said very little, and what she said was direct and not adjusted for the audience. She was not pretty in the manner of Miss Clara Ashford. She was not intended, by anyone present including herself, as a prospect. She was the Bookish Halby daughter, past her prime, brought along to keep Miss Clara company and relieve the Ashford household of one additional person for 3 weeks. I noticed all of this and thought nothing particular about it, and went to bed and woke up thinking about the way she had corrected something Mr. Ashford said about the drainage law, quietly and without making it an event, and been entirely right. I did not know, at that point, that she was going to change my life. I have reconstructed the sequence since, and I believe I had perhaps 4 more days before it became obvious to me, and approximately 3 weeks before I understood what to do about it. Harwick Hall has a library. This is not unusual. Most houses of its size have libraries. What is perhaps unusual is that Harwick's library is genuinely good. 2,000 volumes, well catalogued, including a substantial collection of legal texts assembled by my grandfather, who had been a barrister before he inherited the dukedom, and never fully ceased to be one in his habits. The legal collection had been useful to me on several occasions involving estate disputes and boundary questions, and I had maintained it carefully. I mention this because it is where I first found her. It was the 3rd evening of the season, and I had gone to the library after dinner to review some correspondence from my solicitor in London regarding a matter I will describe presently. It was past 10. I did not expect anyone to be there. She was at the far table near the window, with 3 volumes open before her and a sheaf of papers covered in her own hand. She was writing with the focused efficiency of someone engaged in actual work, not recreation. She did not hear me come in. I stood for a moment in the doorway, and I observed the following. that she had found the section of the shelves I would have directed her to if asked, that the volumes she had opened were the right ones for whatever she was doing, and that her handwriting, visible from where I stood, was precise and rapid and organized into what appeared to be structured argument rather than notes. Then she looked up and saw me and did not startle. She put down her pen. She said, "Your Grace, I apologize. I should have asked permission to use the library. I will come back tomorrow and ask properly." "You may use the library," I said. "What are you reading?" She told me the titles. They were exactly the volumes I would have reached for on the question of copyhold tenure and the legal protections available to tenant families under an enclosure challenge. I said, "Are you working on a copyhold matter?" "Yes," she said, not defensively, simply yes. "Whose?" She looked at me for a moment with the assessment I had noticed at dinner, the quick, thorough kind that is not hostile but is not deferential either. 12 tenant families on the Marston estate, she said. The new owner is asserting a right of enclosure over 3 common fields that the families have held customary rights to for 60 years. I believe the enclosure is unlawful. I am trying to establish the legal basis for a challenge before the quarter sessions in January. I sat down at the opposite end of the table. "Who is your solicitor?" I said. "I do not have one," she said. "I am preparing the brief myself. A solicitor will need to present it, but I have not yet found one willing to take the matter." "Why not?" "Because the families cannot pay," she said, "and because solicitors, in my experience, are disinclined to work for nothing on behalf of tenant farmers they have never met." I looked at the papers. From where I sat I could not read them, but I could see the structure, headed sections, cited authorities, tabulated evidence. "How long have you been working on this?" I asked. 7 months, she said. I said, "May I see it?" She looked at me again with that assessment. Then she pushed the sheaf of papers across the table. I read for 40 minutes. She continued working, adding to a section at the end, and did not watch me, which was the correct thing to do. When I had finished, I set the papers down. I sat with what I had read for a moment. "This is better than anything my own solicitor has produced in the last 3 years, I said. She glanced up. "That is either a compliment to me or an indictment of your solicitor," she said. "Both," I said, "in roughly equal measure." The corner of her mouth moved, not quite a smile, the precursor. "The argument on the 60-year custom is the strongest section," I said. "The prescriptive right claim needs one more authority to be unassailable. Coke on Littleton, 1628, section on customary rights in copyhold. It is on the 3rd shelf from the top on the east wall, 3rd volume from the left." She looked at me. "You know your grandfather's collection very well," she said. "I have had occasion to use it," I said. She stood up and went to the east wall and found the volume exactly where I had said it was. She brought it back, sat down, and began to read. I returned to my correspondence. We worked in silence for another hour. When I left, I said good night. She said good night. She was still reading. I went to my rooms and sat at my writing desk and thought about a woman who had spent 7 months preparing a legal brief for 12 tenant farmers she was not related to, using a library she had no right to use, with no expectation of thanks or recognition, because the enclosure was unlawful and someone needed to say so. I thought about this for a considerable time. She was in the library the following evening, and the one after that. On the 4th evening, I brought my own work and sat at the table without asking permission, and she did not comment on this, and we worked together for 2 hours in the particular companionable silence that I had not experienced since my time at the Inns of Court, when I had occasionally shared a reading room with other young men who were actually interested in the law rather than performing interest in it. The county season proceeded around us without our attention. The drawing room gathered and dispersed. Miss Clara Ashford was admired by 3 separate young men and kept her mother in a state of productive anxiety. The Ashford ladies, having established that Miss Wren was unlikely to be wanted at cards or at dancing, had largely ceased to include her in the evening's arrangements, which suited Miss Wren and suited me, and did not, I think, suit anyone's idea of the proper order of things, but neither of us was especially concerned with the proper order of things. On the 6th evening, she showed me the completed prescriptive rights section, with the Coke Authority incorporated. I read it. It was exact. It closed the argument. "That is it," I said. "Yes," she said, "I think so. The quarter sessions will not be able to dismiss this on legal grounds," I said. "They will have to address the substance." "That is all I am asking," she said. "That someone address the substance." I looked at her across the table, the lamp between us, the legal volumes stacked on either side, her pen still in her hand from the last correction. She looked back. She had the quality I had identified at the first dinner and not been able to fully account for since. The quality of a person who is entirely themselves in every situation, who does not perform and does not manage and simply is, and who expects, with a quiet reasonableness that is more demanding than any explicit requirement, that you will be the same. "Tell me about the families," I said. She put down her pen. She told me. She knew all 12 their names, their tenancies, the length of their family's connection to the land, what they grew and what it cost them, and what the loss of the common fields would mean. She spoke with the fluency of someone who had visited and listened and recorded, not merely assembled facts from a distance. The eldest family had been on the land for 4 generations. The youngest tenant was 23, recently married, with a holding that the loss of common grazing would make unviable within a year. "You visited them," I said. "Of course," she said. "I could not argue for people I had not met." I sat with this. "Most people who prepare legal arguments," I said carefully, "do not visit the people on whose behalf they argue." "Most people who prepare legal arguments," she said, with the same precision, "do not particularly care about the outcome. I care about the outcome." I thought about everything I had observed of her in 6 evenings and 1 dinner, and the particular quality of every exchange we had had. Then I said, "Miss Halby, I would like to offer you the use of my solicitor, Mr. Fenton, to present this brief at the quarter sessions. He is competent, which is more than most, and he will present the argument exactly as you have made it, without improving it or adjusting it, because I will instruct him to do so." She was very still. "That is a considerable offer," she said. "It is a practical one," I said. "The brief deserves to be heard. Fenton can ensure it is heard correctly. The alternative is that you find a solicitor willing to work without fee, which you have not managed in 7 months, and I see no reason why the next month should be different." She looked at me for a long moment. "Why," she said, "you have no connection to the Marston families." "No," I said, "but I have read the brief." I paused. "And I find I am disinclined to watch work of this quality go unheard because the author lacks a solicitor." A silence. "Yes," she said, "thank you, yes." I wrote to Fenton the following morning. "There are things I understood about Wren Halby in stages, the way one understands a landscape not all at once, but in successive clearings as the light changes. The first thing I understood was that she was precise. This was the first thing, precise in her thinking, in her language, in her assessment of evidence. She did not overstate and she did not understate, and she did not adjust her conclusions based on what the conclusion would cost her. This is rarer than it sounds. In 11 years of managing a dukedom, I had met perhaps 4 people of whom it was reliably true, and 3 of them were solicitors. The second thing I understood was that she was kind in the manner that requires strength, the kind of kindness that involves actually knowing the person you are being kind to, which requires attention and time, and a willingness to be inconvenienced. The 12 families on the Marston estate had not asked for her help. She had gone to them, and listened, and then gone home and spent 7 months in other people's libraries making the legal argument that needed making. The third thing I understood was that she was entirely without vanity about any of this. She did not mention the brief to anyone at the season. She did not allow me to mention it. She sat at dinners from which she was largely excluded and ate her food, and observed the room with the clear eyes of a naturalist cataloging an interesting specimen, and went back to the library afterward and worked. I began to understand the fourth thing in the third week, and it took me rather longer to admit to myself what it was. I was looking forward to the evenings, not to the season, which I had never looked forward to the evenings, to the lamp between us on the table and the quiet and the particular quality of a conversation with a person who thinks before she speaks and means what she says and does not require you to be anything other than what you are. I had not looked forward to anything at Harwick in a considerable time. I had concluded some years prior that looking forward to things was a quality one maintained in youth and relinquished, without excessive ceremony, in middle age. I was 37. I had relinquished it. It had, apparently, been waiting to be recovered by the right occasion. The right occasion, it turned out, was a woman who spent her evenings in my library arguing copyhold law by lamplight. I sat with this for several days before I did anything about it. I am a precise man. I do not act on incomplete conclusions. When I was certain of the conclusion, I acted on it. She was in the library. She had been working on a supplementary argument regarding the chain of title, an additional line of attack, she said, in case the prescriptive right claim met unexpected resistance. She was, in my observation, constitutionally incapable of leaving an argument less than fully fortified. I sat down across from her. She looked up. "Miss Halby," I said, "I want to say something to you that is not about the brief." She put down her pen. She gave me her full attention, which was, as I had come to understand, a genuine thing. She did not perform attention, she simply gave it. "I have been watching you for 3 weeks, I said, in the manner of a man who did not initially understand what he was watching but has since arrived at a clear conclusion. I find that I would like, very much, if it is at all agreeable to you, for this not to be the last 3 weeks we spend in this manner." She was quiet for a moment. "That is a carefully worded proposal," she said. "I am a careful man," I said. "I have found in my experience that imprecise proposals lead to imprecise outcomes, and I have no interest in imprecise outcomes." "What is the precise outcome you are proposing?" she said. "Marriage," I said. "To begin with the end and work backward, which I believe you would prefer to the alternative." The corner of her mouth moved again, that precursor. "You are asking me," she said slowly, "on the basis of 3 weeks in a library." "On the basis," I said, "of 3 weeks during which I have read your legal brief, observed your thinking, learned the names and tenancies of 12 families you have never been thanked for helping, and found that the only evenings at Harwick I have looked forward to in 11 years of county seasons are the ones in which I am sitting across this table from you. That is the basis. I am aware it is not conventional." "It is not conventional," she agreed. "No," I said, "but it is precise." She looked at me for a long moment, the lamp between us, the legal volumes, the sheaf of papers with her handwriting covering every margin. "I should tell you," she said, "that I am 28 years old and have been told, with some regularity, that I am too bookish and too opinionated, and too far past the conventional age for this kind of consideration to be seriously extended." "Yes," I said, "I am aware. I have heard it said in this house in this season by people whose opinion on the matter I find entirely without value." Something shifted in her face. "I should also tell you," she said more quietly, "that I had not expected, I had concluded some time ago, that this kind of thing was not going to be available to me. I had made my peace with it. I was not unhappy." "I know," I said. "I could see that you were not unhappy. It was one of the things I noticed. And she said, and I said, I find I am considerably more interested in what would make you happy than in what has been decided about you by people who have not read your work. A long silence. Yes, she said. All right, yes then. I sat across from her for a moment. The conclusion had been reached. I found, and this was, I will admit, not an entirely familiar sensation, that I was glad. Good, I said. We should finish the supplementary argument. Fenton will need it by the end of the week. She looked at me. Then she laughed, a genuine one, sudden and warm, and it changed the quality of the library entirely. Yes, she said, picking up her pen. We should. The quarter sessions were held in the county town of Caldwell on the 14th of January, in a room that smelled of damp wool and old timber, and the particular staleness of a space in which important decisions have been made for a very long time. Mr. Fenton presented the brief. He presented it exactly as Wren had written it, without improvement or adjustment, because I had instructed him to, and because he was, as I had said, competent. The argument on the 60-year custom came first. The prescriptive right argument with the Koch authority came second. The chain of title supplementary argument, which Wren had finished the day before Fenton needed it, came third. The opposing counsel, who represented the new owner of the Marston estate, was a capable man. He was also, it became apparent within the first 20 minutes, not as prepared as he had expected to need to be. The brief was better than he had anticipated. He had been anticipating a routine challenge, informally assembled. He had not anticipated this. The magistrate asked, at one point, who had prepared the document. Fenton said, "The brief was prepared by Miss Wren Halby, of Ashfield-under-Moor, who has been engaged in this matter for the better part of a year." There was a silence in the room. Not all of the county gentry who had been at Harwick that autumn were in the Caldwell Sessions room, but enough of them were. I watched the particular quality of that silence, the recalibration of a room that has been presented with a fact that does not fit its existing categories. I was sitting in the gallery. Wren was beside me. She was watching the magistrate, not the room, with the focused attention of a woman waiting to hear whether the argument holds. The magistrate ruled in favor of the 12 tenant families on the 22nd of January. The enclosure was found unlawful. The common fields remained common. We were married in March, in the church at Ashfield-under-Moor, before a congregation that included the 12 tenant families, all of them, from the eldest to the youngest, and a substantial portion of the Derbyshire county gentry, who attended partly out of genuine goodwill and partly, I suspected, out of the same impulse that draws people to reconsider something they had previously miscategorized. The Reverend Halby, Wren's father, performed the ceremony. He wept at 2 points which he had not expected to do, and managed the text admirably in between. Fenton sent a gift, and a letter in which he said that the prescriptive rights section had been, in his professional opinion, the finest piece of legal argument he had seen produced outside the Inns of Court in 20 years of practice, and that he hoped to be of further service. Wren read this, and set it aside with the expression of someone who had known this, and not required the confirmation, but was not displeased to have it. She has been at Harwick for 6 years. The library has been reorganized. She has catalogued it properly, which it needed, and added 40 volumes, 12 of which are legal texts and 4 of which are novels that she said a house of this size ought to have, and I did not argue with. She has taken on 2 more cases since the Marston matter, one involving a disputed right-of-way in the north of the county, one involving a question of inheritance affecting a family in the next parish. She has won both. The county drawing rooms have recategorized her entirely, which she has neither encouraged nor discouraged. She finds it mildly interesting, in the manner of a naturalist observing a specimen adjust to new conditions. I find her, as I found her on that first evening at the end of the dinner table, entirely without performance, entirely herself, and more interesting than anything else in any room she is in. I told her this once in the library, on an evening very much like the ones in which this began, the lamp between us, the legal volumes, her pen in hand. She said, "That is a very precise compliment." "I'm a precise man," I said. She looked at me over the top of the volume she was holding, with the clear, reading assessment I had known since the third evening of the 12th county season, and which I have never once wanted to look away from. "Yes," she said, "you are," and she went back to her reading. I went back to mine. It is, I want to record, the best thing that has ever happened to me, sitting across this table from this woman, in this library, in the particular companionable quiet of two people who have nothing to perform for one another and a great deal still to learn.